Today we're going to talk about 5 common mistakes that we often see executors, administrators, and trustees make when selling homes in probate or trust. And stick around, we actually have one additional mistake that we often see made. Mistake number 1. Let's talk about not making contact with beneficiaries and heirs and providing notice on time. We always recommend to our clients staying in regular contact with all heirs and beneficiaries for an estate. This is because many times when there are issues in the courts or with the distribution of the estate, it has to do with disputes between siblings or other heirs. What do we mean by that? Well, you may have an aunt who is supposed to inherit grandma's vase that's been sitting on the counter in the hall for the last 10, 15 years. And if you're not in contact with said aunt, letting her know what the situation is regarding that vase, she may get upset if she notices that it's not on the counter when she comes by the property, or if she doesn't receive it quickly after your grandmother has passed. This can turn into a bigger problem for you. If you're in probate, she could potentially hire her own attorney and come at you from a legal standpoint, trying to fight you for the right to sell the estate. Or she could just get upset and start arguing with you or other heirs or telling people in the family things that may not be necessarily true, but could be causing additional problems for you in the future because you'll be fighting with other family members over items being distributed. This seems like an extreme situation, but a lot of times what we see is that when the executor, administrator, or trustee isn't in regular communication with the rest of the beneficiaries or heirs, it causes disputes between the family. So what we recommend is ask your real estate agent and your attorney to regularly send you emails. This gives you written documentation of what the situation is regarding any property in the estate and the process for probate or the trust. And you can take that information and you can tailor it so that you can send out a mass email to all heirs and beneficiaries. It gives them a little bit of an update as to what the situation is with the estate, and it also takes a lot of the extra work off of your plate. If there aren't too many beneficiaries, you may also find that it's helpful to just make a phone call and talk to everybody. You can choose to Zoom, video chat, you could send some text messages. All of these things are very helpful in preventing disputes between any of the beneficiaries, and they save you a lot of heartache and headache later on down the line. Let's talk about mistake number 2. Poorly planned documentation or incomplete disclosures. We recently spoke with someone who had a situation where their agent had neglected to put inspection timelines into their documentation. This actually caused a lot of hassle for the executor because what ended up happening is that they got most of the way through the sale and the buyers backed out literally one day before closing without any damages going to the estate. What does this mean? Well, the buyers had to put in a down payment to purchase the property. And usually the way that it's set up is that there is an inspection contingency period. We typically set ours up for 7 to 10 days, which gives the buyers time to come in and do all of their inspections. Well, what ended up happening is that this executor's agent had neglected to put into the documentation that this timeline was a part of the agreement between the buyers and the executor, the seller. So what happened was the buyers were able to get almost entirely through the escrow process. They had one day before they were supposed to close and they were able to back out and still get all of their deposit back. This meant that the property was off the market for 30 days with no offers coming in and no one able to show because they were in escrow with a particular buyer. This is not the way that you should set up a listing. It's not the way that you should do your documentation. So with that being said, it's really important to hire an experienced real estate agent, especially with properties in probate, so that they can help you to get through the process in a timely manner and protect you from potentially sitting on the market for longer than you should without any risk to the buyer if the buyers don't hold up their side of the agreement. Another issue that we see sometimes is incomplete or disclosures that don't represent the situation. Many times with probate and trust properties, the executors, administrators, and trustees, the ones who are running the estate, they don't live in the home and they live out of town. Sometimes they don't even know the person whose home it was. It could be a distant uncle or a distant relative that you're no longer in connection with. They may not have any details about what's happened at the property. So because of that, we have specific disclosures that we go over with our clients, and we work with them to give all information that they do have, but be clear that there are certain details that they may not know. Another piece is incomplete disclosures. If you do know something about the property, you need to disclose it. Let's say you know that grandma had the roof redone. Maybe you don't have the details on specifics as to when the roof was redone, but maybe you have a document that is a receipt from the roof being replaced. That there is a disclosure that you need to provide when you get into escrow. It's important to have an agent who's going to represent you and help you with these documentation so that everything is clear for the buyers and you're also protected from any potential liabilities to the estate. Mistake number 3, not following timelines for probate. This has to do with the courts, and really you should be relying on your attorney to help you with these timelines. But many times there are set timelines for how long your letters of administration will be good for. They have an expiration date, and you really need to handle things and get them taken care of within that timeline. Deadlines for court aren't flexible. So if for some reason you're not going to be able to follow through with those deadlines, you do need to have your attorney contact the courts and adjust the documentation so that those timelines can be met. Be sure to speak with your attorney about this, as they're the ones who are more versed in the specifics of your case and the timelines associated with them. Mistake number 4, not ensuring that you have a clear title and that debts have been paid. It's important to know that the title on the property is clear and free of any potential issues. And the way you're going to know that is by having a title company review that. If you have an experienced real estate agent, they will contact a title company and have them review. In regards to debts, it's important that when you have a company that has a financial stake in the property, to keep them informed as to what the situation is regarding the sale. Many times, mortgage companies, for example, are willing to be flexible when it comes to getting through a probate and having a property sell so that they can be paid. They just like to know what the situation is regarding that. Taking care of these situations early when it comes to title and debt is going to save you a lot of hassle later and will prevent any panic at the last minute. Mistake number 5, failing to secure the property. As the executor, administrator, or trustee, it's your responsibility to ensure that the property and all assets inside are secured. We recommend that you have the locks changed relatively early on after the death to ensure that family members and other beneficiaries are not just coming in and out of the home. You don't know who has a copy of that key, and so it's important for you to make sure that the locks are changed and you have fresh keys to prevent anyone from going in and taking items from the estate. We also recommend that you put in an alarm system if you believe that there is anyone who potentially could be breaking into the home, or if the home is nowhere near where you live. And this is because a vacant property is an easy target for people who want to break in and steal items, or even potentially squatters who could come in and take access to the property, which could be a huge problem for you later on down the line. We actually have a temporary alarm system here in San Diego that we've worked with, who will come in and they will install an alarm system for a set fee, and then they will charge a monthly fee just to have that alarm system in place. It protects you as the executor, administrator, or trustee from being held liable for any losses to the estate, because you will have proof that you took the time and put in the effort to have the locks changed and to protect the home from any potential break-ins or theft. Remember, as the representative for the estate, you have a legal responsibility to protect the assets, and so following these steps is a way for you to do that. At the beginning, I said I had one additional mistake that I wanted to talk to you about. That is letting emotions take the lead. As the representative of the estate, letting your emotions take the lead is one of the worst things that you can do, because it can actually cause you to get bound up in your connections as opposed to handling the estate as a representative. We don't mean that to be a harsh thing, but what we do mean is that take your time to grieve, but know that you have a responsibility as the personal representative to make sure that all of the personal items in the home are distributed how they need to be distributed, and that the home itself is either sold or handled the way that the estate requests it to be. Your loved one had a plan. It might be a will, it might be a trust. And if they had a plan, then it's your responsibility to ensure that that plan is followed through with. It's important that you honor your loved one, but that you lead with strategy and that you move forward through the process. Take your time to grieve, but don't let emotions get you bound up. If you're an executor, administrator, or trustee, and you feel like you need guidance through this process, and you're concerned about these mistakes, please reach out to us. We would love to help you through the process or to get you in touch with a professional who can guide you through. Thank you for watching. Don't forget to like, comment, and subscribe, and hit that bell button. We'll see you next week.